Canada's new anti-soliciting law suffered its first setback yesterday when a Vancouver judge ruled that the law is too broad in banning soliciting in places open to public view. Specifically, the ruling struck out the section of the law that includes a motor vehicle as a public place. This morning, we're joined in Vancouver by Tony Serka. He's the lawyer for the woman who challenged that law. Good morning, Mr. Serka.
Good morning, Norm.
Can you explain fairly simply just what the judge decided, what he actually said?
Well, what the judge did was very significant. He excised or took out subsection 2 from the prostitution legislation, which means that there is no more definition enclosed as to what public place is. The definition of public place in the Act was any motor vehicle located in a public place, any place that was open to public view, and the usual definition of public place.
Yeah, he says the phrase, any public place, far exceeds the purpose and intent of the law.
That's right. So we have to go back to case law to see what a public place is, and that means we go back to the Deborah Hutt case in 1978.
That was another case you were involved with, wasn't it?
Yes, and that the Supreme Court of Canada ruled in that particular case that an undercover officer's car was a private place and not a public one.
Does that mean, then, Mr. Serka, that it is now legal, quote unquote, for a prostitute to conduct her business in an automobile?
Well, if this case is upheld, and you have to remember that this is a provincial court decision, which means that another provincial court judge could go the other way.
Right.
So I wouldn't counsel anybody that it's okay to communicate about sex in a car, but it's significant in that if that is the logical extension of this particular case, the McLean case.
Now, you did try and get the whole law struck down by saying that it was unconstitutional. The judge, if I understand properly, said this one section perhaps is unconstitutional, but the rest of the thing is still constitutional, which means your client still has to face the charges in court, right?
That's right. There was a four-pronged attack. My main attack, or the main attack of the defense, was that the legislation was too vague.
All right. If your client still has to face those charges, if the judge decided that most of this law still is constitutional, what have you achieved?
Well, I think the police in Vancouver have already admitted that most of their cases are in jeopardy now, because most involve communication between a John and a prostitute inside a car. This would, if this case was followed, of course, there shouldn't be convictions on those particular fact patterns, and people will know how to conduct themselves. One of the most important parts of a criminal law is that a person knows if what they're doing is criminal or if it is not criminal. Now they might have more of an inkling as to what position they're in.
Yeah, because your argument was that a person could be in a house, and if the blind isn't drawn or if the window is open and the public can look in, then that's a public place, and thereby they're committing they're violating the law.
That's right. My argument was that this legislation far surpassed what it was aimed at. It was aimed at street soliciting, and it went far further than that.
Do you intend to appeal now the fact that the judge decided the rest of the law is constitutional?
I will be talking with my client later on today, and that's going to be the main topic of conversation between us.
Justice Minister John Crosby said that he expected the new law, the new anti-soliciting law, when it was brought in, would act as a deterrent rather than a weapon against prostitution. Now, you've been dealing with these cases for many years. Do you find that that is indeed the case?
Well, it is a deterrent. If he said that a prostitute and a John would be machine gunned on the street, that would be a deterrent too. It's a very draconian law. It goes too far. It affects the life and liberty of the individual under the Charter of Rights. And in fact, the success of this argument is based on Section 7 of the Charter of Rights.
What has been the effect so far of the new law on prostitution?
Well, initially, it was being packaged as a law that would apply equally to customers and prostitutes, and we've seen that at the start. That's how cosmetically it was done. You had one John arrested, then one prostitute, one John, one prostitute. Yeah. Now you can see it's at a 2-to-1 ratio. It's definitely a law designed to act against the weak.
In other words, it didn't really serve the purpose that it was supposedly going to do, that is, get both the Johns and the prostitutes.
Well, no, I think it served the purpose, yeah. But the point is that it's an unconstitutional law in our submissions.
Yeah, not according to the judge, it's not. The judge says that one section of a public place may be, but as far as Judge Libby is concerned, the rest of the law is quite constitutional.
Yes, but that decision alone may be quite